And greetings. Welcome to the 237th anniversary of the Northwest Ordinance, enacted on this date in 1787. That said, for those that aren't aware, the Northwest Ordinance was the portion of land northwest of the Ohio River. And nowadays it has the states of Ohio, Indiana, Illinois, Michigan, Wisconsin, and a little part of Minnesota. That being said, there were various companies, estate owners, and landholders in this area, as well as some native tribes, and it had to be worked out, basically a way of organizing and I guess having the rightful claims of landholders honored as well, and still to fit into the new law of the land of America that had just come into being simply 10 years earlier. So, considering those times and the way the land was pretty much very rugged and not really conquered, so to speak, at that time, and full of outposts from the various colonies, or colonial masters, we should say. So, as the new American experiment started to expand, the Northwest Ordinance was a major part of it, and part of it was, or I say, the Northwest Territory, and the Northwest Ordinance was the law that went with this new land. That being said, let's get started. So, the Ordinance of 1787, the Northwest Territorial Government. All right, let me zoom in on this a little bit better now. Oh, Lord. There we go. Okay. So this was from the Confederate Congress of July 13th, that's today's date, but of 1787. An ordinance for the government of the territory of the United States northwest of the River Ohio. Section 1. Be it ordained by the United States in Congress assembled that the said territory for the purpose of temporary government, interesting there, temporary government, be one of district, subject, however, to be divided into 2 districts, as future circumstances may, in the opinion of Congress, make it expedient. And this is in Section 1. Then we go to Section 2. Be it ordained by the authority aforesaid that the estates of both resident and non-resident proprietors in said territory, dying intestate, meaning that there's no direct will, shall descend to and be distributed among their children, and the descendants of a deceased child in equal parts, the descendants of a deceased child or grandchild to take the share of their deceased parent in equal parts among them, and where there shall be no children or descendants, then in equal parts to the next of kin in equal degree, and among collaterals, the children of a deceased brother or sister of the intestate shall have in equal parts among them their deceased parents' share. And there shall in no case be a distinction between kindred of the whole and half-blood. Interesting there. Now think about this, especially in those times, that the kindred of whole or half-blood entitled you to part of that estate, saving in all cases to the widow of the intestate her third part of the real estate for life. Third, huh? 1/3 of the part of the personal estate, and this law relative to descents and dower shall remain in full force until altered by the legislature of the district. So this is basically about the conveyance of I guess, intestate inheritance. And until the governor and the judges shall adopt laws, as hereinafter mentioned, estates in the said territory may be devised or bequeathed by wills in writing, signed and sealed by him or her in whom the estate may be, being of full age, and attested by 3 witnesses. And real estates may be conveyed by lease and release, or bargain and sale, signed, sealed, and delivered by the person being of full age in whom the estate may be, and attested by 2 witnesses, provided such wills be duly proved, and such conveyances be acknowledged, or the execution thereof duly proved, and be recorded within 1 year after proper magistrates, courts, and registers shall be appointed for that purpose. And personal property may be transferred by delivery, saving, however, to the French and Canadian inhabitants and other settlers of the Kaskaskis, St. Vincent's, and the neighboring villages, who have heretofore professed themselves citizens of Virginia. Citizens of Virginia, interesting. Their laws and customs now in force among them relative to the descent and conveyance of property. So an interesting word here of citizens, which we don't really find in the beginnings of the Constitution or the Bill of Rights, which is in 1789. This is 1787, and we're seeing the word citizens of Virginia here. So this is an interesting area to research further. So we're on to Section 3. Be it ordained by the authority aforesaid, that there shall be appointed from time to time by Congress a governor, whose commission shall continue in force for the term of 3 years, unless sooner revoked by Congress. So at the pleasure of Congress, they would appoint the governor, who could be revoked within that 3-year term. He shall reside in the district and have a freehold estate therein. So he must hold in free that estate inside the district in 1,000 acres of land while in exercise of his office. So you have to own 1,000 acres of land if you want to be the governor. Interesting. And then you're appointed by Congress. But to be qualified, you need that 1,000 acres freehold land. Okay, Section 4. Now this is an interesting part here too. There shall be appointed from time to time by Congress a secretary, whose commission shall continue in force for 4 years, unless sooner revoked. He shall reside in the district and have a freehold estate therein in 500 acres of land, so half as much as the governor, at least. Let's see, freehold estate. While in exercise of his office, it shall be his duty to keep and preserve the acts and laws passed by the legislature and the public records of the district, and the proceedings of the governor in his executive department, and transmit authentic copies of such acts and proceedings every 6 months to the Secretary of Congress. So this secretary here of the his commission, right? He's reporting all these things from all their authentic copies. There shall also be appointed a court to consist of 3 judges, any 2 of whom to form a court, who shall have a common law jurisdiction and reside in the district, and have each therein a freehold estate in 500 acres of land, while in exercise of their offices, and their commissions shall continue in force during good behavior. Good behavior. Who determines that? Section 5. The governor and judges, or a majority of them, shall adopt and publish in the district such laws of the original states, criminal and civil, as may be necessary. So they shall adopt and publish of the original states, that's our 13 colonies there, as may be necessary and best suited to the circumstances of the district, and report them to Congress from time to time, which laws shall be enforced in the district until the organization of the General Assembly therein, unless disapproved by Congress. But afterwards, the legislature shall have authority to alter them as they shall think fit. So we're given a lot of authority here on the Congress here for governing this. But remember, this is a temporary government, they say here. Section 6. The governor, for the time being, shall be commander-in-chief of the militia. So the governor is commander-in-chief for the time being. Appoint and commission all officers in the same below the rank of general officers. All general officers shall be appointed and commissioned by Congress. So the generals still in control there, but the governor shall be the commander-in-chief. Big role there. Governor has 1,000 acres and a lot of authority. Section 7. Previous to the organization of the General Assembly, the governor shall appoint such magistrates and other civil officers in each county or township as he shall find necessary for the preservation of the peace and good order in the same. After the General Assembly shall be organized, the powers and duties of magistrates and other civil officers shall be regulated and defined by the said assembly. But all magistrates and other civil officers not herein otherwise directed shall, during the continuance of this temporary, remember this is a temporary government, be appointed by the governor. All right. Section 8. For the prevention of crimes and injuries, the laws to be adopted or made shall have force in all parts of the district. And for the execution of process, criminal and civil, the governor shall make proper divisions thereof. And he shall proceed from time to time, as circumstances may require, to lay out the parts of the district in which the Indian titles shall have been extinguished into counties and townships, subject, however, to such alterations as may thereafter be made by the legislature. So the governor is able to extinguish some of the claims of Indian titles. Shall have been extinguished. He's going to make sure into counties and townships. But the alterations may be made by the legislature, of course. All right, so let's continue down on to Section 9. And while we're here, let's double check also in the chat. We have audit them. Yes, sir. And salute, of course, to Captain Jack in the house. And yes, there's a link to the PDF. There's a lot of these, and you can find them from the government archives is where I got this. They have both this, and they also have a nice scanned version you see in the background here. But, of course, the one we're on here is much easier to read. So we're sticking with this one. Right, let's continue. Section 9. So soon as there shall be 5,000 free male inhabitants, 5,000 free male inhabitants of full age in the district, upon giving proof thereof to the governor, they shall receive authority with time and place to elect representatives from their counties or townships to represent them in the General Assembly, provided that for every 500 free male inhabitants, there shall be one representative, and so on progressively, with a number of free male inhabitants shall the right of representation increase until the number of representatives shall amount to 25, after which the number and proportion of representatives shall be regulated by the legislature, provided, okay, so before we go for the next provision here, every 5,000 free male inhabitants, okay, we're not saying citizens here, they're saying inhabitants. So anyone that's living on that land, that's a free and they're a male, there shall be one representative. This is an interesting distinction here because we're not saying citizens. And that's why I believe in the census that you'll find that they're measuring all the inhabitants, not just citizens, etc. Although they may question further into status, that's not the intent. Is to get a total head count, really. There shall be one representative, and so on, progressively. So for every 500, you get a representative. You had to have at least 5,000 in the district, right? So you can do the math there, but we're going to go on till we can't have more than 25, after which that number and proportion shall be regulated. So you get up to 25 depending how fast you grow of free males inhabitants. Okay, provided there that no person be eligible or qualified to act as a representative unless he shall have been a citizen of one of the United States 3 years. Okay, so we're at 1787, so we're getting pretty darn close to the Revolutionary War time. So it's these are all pretty much fresh blood over there. And be a resident in the district, or unless he shall have resided in the district 3 years, and in either case shall likewise hold in his own right, in fee simple, 200 acres of land within the same. So that's an or. Where was that? Or unless he shall have resided in the district 3 years. So now not inhabited, resided. This is someone that may not have to be a citizen. Shall be a citizen and be a resident, or unless he shall have resided. Maybe this is only the qualification as resident. Reside in the district 3 years, and in either case, shall likewise hold in his own right, in fee simple, 200 acres of land within the same. So, provided also that a freehold in 50 acres of land in the district, having been a citizen of one of the states and being a resident in the district, or the like freehold and 2 years, residence in the district shall be necessary to qualify a man as an elector of a representative. They just want to make sure that you're not some kind of carpetbagger just jumping in the game here. They want you to have some kind of stake there. So you have to be holding land free in fee simple, and you also have had to inhabit or reside in that area for 3 years, etc. And I guess that's so you have some skin in the game. So, Section 10. The representatives thus elected shall serve for the term of 2 years, and in case of the death of a representative or removal from office, the governor, of course the governor, shall issue a writ to the county or township for which he was a member to elect another in his stead to serve for the residue of the term. Section 11. The General Assembly or Legislature shall consist of the governor, legislature, council, or legislative council, and a House of Representatives. So the General Assembly or Legislature consists of the governor, a legislative council, and a House of Representatives. The Legislative Council shall consist of 5 members to continue in office 5 years, unless sooner removed by Congress, any 3 of whom to be a quorum, and the members of the council shall be nominated and appointed in the following manner, to wit, as soon as the representative shall be elected, the governor shall appoint a time and place for them to meet together, and when met, they shall nominate 10 persons resident in the district and each possessed of a freehold in 500 acres of land, and return their names to Congress, 5 of whom Congress shall appoint and commission to serve as aforesaid. And whenever a vacancy shall happen in the council by death or removal from office, the House of Representatives shall nominate 2 persons qualified as aforesaid for each vacancy and return their names to Congress, 1 of whom Congress shall appoint and commission for the residue of the term. And every 5 years, 4 months at least before the expiration of the time of service of the members of the council, the said House shall nominate 10 persons qualified as aforesaid and return their names to Congress, 5 of whom Congress shall appoint and commission to serve as members of the council 5 years, unless sooner removed. And the governor, Legislative Council, and House of Representatives shall have authority to make laws in all cases for the good government of the district, not repugnant to the principles and articles of this ordinance, established and declared. Now, this is important language right here. I know I've been going on with some of the stuff here, but this is something to pay attention to because this comes back later. The governor, Legislative Council, House of Representatives shall have authority to make laws in all cases for the good government of the district, not repugnant to the principles and articles in this ordinance, established and declared. So we're going to get to that soon. And all bills having passed by a majority in the House and by a majority in the council shall be referenced to the governor for his assent. But no bill or legislative act whatever shall be of any force without his assent. The governor shall have power to convene, prorogue, and dissolve the General Assembly when, in his opinion, it shall be expedient. So, again, the governor is really the one running the show. He's the one that regulates everything here. He speeds up, slows down the gears of government. The governor, judges, legislative council, secretary, and such other officers. Now, we've already gone over this. The governor, he's the one that appoints, calls the shots on a lot of things, fills vacancies, etc. Judges, legislative council, which there is, 5 of them? Secretary, who's supposed to report all this stuff and get those certified copies out, and such other officers as Congress shall appoint in the district shall take an oath or affirmation of fidelity and of office. The governor before the president of Congress, and all other officers before the governor. So we have a chain of custody here of that oath. As soon as a legislature shall be formed in the district, council and house assembled in one room shall have authority by joint ballot to elect a delegate to Congress who shall have a seat in Congress with a right of debating, but not of voting, during this temporary government. So before statehood, they could have a delegate to Congress who will have a seat with a right of debating, but not of voting, but at least a voice and a seat. Section 13, and for extending the fundamental principles of civil and religious liberty, which form the basis whereon these republics, their laws and constitutions are erected, to fix and establish those principles as the basis of all laws, constitutions, and governments, which forever hereafter shall be formed in the said territory, to provide also for the establishment of states. Remember, they need to make states out of this territory, and permanent government therein, and for their admission to share in the federal councils on an equal footing with the original states, at as early periods as may be consistent with the general interest. And before we go on to that, as you see from the map, these states had not yet been carved out there in that territory. So this is overlay of the current states, but that's not how they were at the time. So this is yet to be done, but this is how it ended up being admitted to the Union with the equal authority of the other states. So we're on to section 14. It is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people and states in the said territory, and forever remain unalterable, unless by common consent, to wit. All right, we're on to Article 1 now. Good stuff. If anyone here has just joined us, please hit the like and let people know that we're here celebrating the anniversary of this very important milestone in the American experiment, which is the Northwest Ordinance that was enacted on this date in 1787. So, Article 1, no person demeaning himself in a peaceable and orderly manner shall ever be molested on account of his mode of worship or religious sentiments in the said territories. So, freedom of religion right here. Article 2. Now, remember, this is before the Bill of Rights. And most of this, I believe, is penned by Thomas Jefferson, so keep that in mind. The inhabitants of the said territory shall always be entitled to the benefits of the writs of habeas corpus and of the trial by jury. Now, remember, this is all before the Bill of Rights. Of a proportionate representation of the people in the legislature, and of judicial proceedings according to the course of the common law. All persons shall be bailable, unless for capital offenses, where the proof shall be evident, or the presumption great. All fines shall be moderate, and no cruel or unusual punishments shall be inflicted. No man shall be deprived of his liberty or property, but by the judgment of his peers, or the law of the land, and should the public exigencies make it necessary for the common preservation to take any person's property or to demand his particular services, full compensation shall be paid for the same, and in the just preservation of rights and property, it is understood and declared that no law ought ever to be made or have force in said territory that shall, in any manner whatever, interfere with or affect private contracts or engagements, bona fide and without fraud previously formed. Wow. Sound familiar? And this is all before the Bill of Rights, remember. Why couldn't they have kept some of this stuff as simple as we're reading here? Let's move on to Article 3. Religion, morality, and knowledge being necessary to good government, and the happiness of mankind. Who would think? Schools and the means of education shall forever be encouraged. It doesn't say they are going to manage or have departments of education. It said forever be encouraged. The utmost good faith shall always be observed towards the Indians. Their lands and property shall never be taken from them without their consent. And in their property, rights, and liberty, they never shall be invaded or disrupted. unless in just and lawful wars authorized by Congress. Geez. But laws founded in justice and humanity shall, from time to time, be made for preventing wrongs being done to them, and for preserving peace and friendship with them. So this is a nice sentiment here. We see how long that lasted. However, let's move on to Article 4. This is a very prominent one here. The said territory and the states which may be formed therein shall forever remain a part of this Confederacy of the United States of America, subject to the Articles of Confederation and to such alterations therein as shall be constitutionally made, and to all the acts and ordinances of the United States in Congress, assembled, conformable thereto. The inhabitants and settlers of the said territory shall be subject to pay a part of the federal debts, contracted or to be contracted, and a proportional part of the expenses of government to be apportioned on them by Congress, according to the same common rule and measure by which apportionments thereof shall be made on the other states. Now, remember, this whole thing about taxes and such, you can rub the states pretty wrong with this kind of language here. So let's see how they massage this one here. And the taxes for paying their proportion shall be laid and levied by the authority and direction of the legislatures of the district, or districts, or new states, as in the original states, within the time agreed upon by the United States in Congress assembled. The legislatures of those districts, or new states, shall never interfere with the primary disposal of the soil by the United States in Congress assembled, nor with any regulations Congress may find necessary for securing the title in such soil to the bona fide purchasers. No tax shall be imposed on lands, the property of the United States. Wait, let me read this part here again. No tax shall be imposed on lands, the property of the United States. And in no case shall non-resident proprietors be taxed higher than residents. The navigable waters leading into the Mississippi and St. Lawrence, those are the rivers there, and the carrying places between the same shall be common highways. Remember, back then there were no highways on the land. The highways were in the waterways. And forever free. So the navigable waters leading into the Mississippi and St. Lawrence and the carrying places between the same, those are the little tributaries between them, shall be common highways and forever free. As well to the inhabitants, not citizens, the inhabitants of the said territory, as to the citizens of the United States. Notice they have to use this language to make the distinction. And those of any other states that may be admitted into the Confederacy without any tax imposed or duty thereof. Beautiful. We're on to Article 5. There shall be formed in the said territory not less than 3 nor more than 5 states, and the boundaries of the states, as soon as Virginia shall alter her act of cession and consent to the same, shall become fixed and established as follows, to wit: the western state in the said territory shall be bounded by the Mississippi, the Ohio, and the Wabash rivers. So let's take a look at our map here. Okay, you can take your guess where those other rivers are. A direct line drawn from the Wabash and Post Vincent's due north to the territorial line between the United States and Canada, and by the said territorial line to the Lake of the Woods and Mississippi. The middle state shall be bounded by the said direct line in the Wabash from the Post Vincents to the Ohio, by a direct line drawn between, okay, we could look at the map for all this. So again, whatever they're saying here, I know how it ended up being, but this is how it ended up, regardless of all these lines being drawn here. Provided, however, that is further understood, and let's get back here, and declare that the boundaries of these three states shall be subject so far to be altered that if Congress shall hereafter find it expedient, they shall have authority, to form one or two states in that part of said territory which lies north, east-west line drawn. Okay, so we get all these lines here. Okay. Whenever any of the said states shall have 60,000 free inhabitants therein, such state shall be admitted by its delegates into the Congress of the United States on an equal footing with the original states, and in all respects whatever, and shall be at liberty to form a permanent constitution and state government, provided the constitution and government so to be formed shall be republican, and in conformity to the principles contained in these articles. Wait a second. So to form permanent constitution and state government, provided, right, they shall be republican. Of course, they're representative republics, all these states we looked at, and in conformity to the principles contained in these articles. So the conformity with these articles here, the principles. And so far as it can be consistent with the general interest of the Confederacy, such admission shall be allowed at an earlier period and when there may be less number of free inhabitants in the state than 60,000. Now we move on to Article 6. So interesting, these principles the way this words here, that to form the permanent constitution, be in conformity with the principles contained in these articles. So now let's get to Article 6. This is 1787. Article 6. There shall be neither slavery nor involuntary servitude in the said territory, otherwise than in the punishment of crimes whereof the party shall have been duly convicted. Wait a second. So in 1787, there shall be neither slavery nor involuntary servitude in the said territory. This is before the 1789, the Constitution in Congress, and before the Bill of Rights. There shall be neither slavery nor involuntary servitude in the said territory, otherwise than in the punishment of crimes, whereof the party shall have been duly convicted, provided always that any person escaping into the same, from whom labor or service is lawfully claimed in any one of the original states, such fugitive may be lawfully reclaimed and conveyed to the person claiming his or her labor or service as aforesaid. Notice they're not saying property. They're not looking people as property, is saying labor or service lawfully claimed, which would imply contract, I believe. Be it ordained by the authority aforesaid that the resolutions of the 23rd of April, 1784, relative to the subject of this ordinance be, and the same are hereby repealed and declared null and void. Done by the United States in Congress assembled the 13th day of July in the year of our Lord, 1787, and of their sovereignty and independence, the 12th. Interesting stuff here when you think about the principles that must apply for the permanent constitution and state laws of these states in this territory. quite something to consider, especially when principles are something that persists and don't require proof. Principles prove. And if they must be in conformity to those principles for their permanent constitutions, that implies that all those articles are still in effect. So, food for thought there. And on this day, to remind us of what happened here quite some time ago, 237 years ago, the anniversary of the enactment of the Northwest Ordinance. I thank everyone for coming in here tonight to share this review with me. I hope there's still people in the room here. If you want, check in the chat. If there's anything else we need to detail here, you're welcome there. Maluhaya. And everybody else that showed up here tonight. Salute to all of you for showing interest in a very important part of our history here, and something that we all should be aware of, considering that there's so much focus on things like the Bill of Rights and the Constitution, yet there are principles here that were predecessors to that, penned by Thomas Jefferson in part, and a lot of question as parts with the slavery and why that part was left out of the Bill of Rights until the 13th Amendment or so. It opens up a lot of questions, and I think the fact that many people aren't aware of the Northwest Ordinance and it's important is why these questions aren't frequented more. So salute to you all for coming out, learn more about this Northwest Ordinance on this date, and I'll see you all in the next one. Peace out.